It's a pleasure to be here and to be here with you. It's my first opportunity to present in front of a panel of 150 judges. Let's hope that I can make my way through it. I want to build on the terrific background that Allison has given about the sort of core handful of implied conflict and express preemption cases from the court over the past several years and give you my sense of what is really up in these cases. If we were to think about, okay, now I know if I have a class 3 medical device case, I know what to do. Medtronic's going to tell me that the FDA's pre-market approval of that medical device is going to preempt a state tort suit. That's good to know. But it's entirely possible that I'm actually going to have the next generation of case. As Allison says, there's the open question of what it is that defendants and equally plaintiffs' lawyers will turn to as the vehicles for pursuing or defeating claims under state law. And so I want to give you my sense of the sort of attitudinal direction of the court, what's motivating these cases. I want to start, however, Allison said she needed to start with the framework of these tort cases, and I agree with that, but I want to step back one step further than that, and that is to start with the constitutional framework, which is all pretty obvious, but just to start at the very beginning, the Constitution's supremacy clause obviously tells us that federal law wins in a fight with state law. Now, when the framers of the Constitution wrote the supremacy clause and the states adopted it, they probably had a more narrow view of what federal power was. The Commerce Clause now is a blank check. You can agree or disagree with it, but all that is required for Congress's power to come into play, and therefore its ability to preempt state law to come into play, is that Congress feels like doing something. That's basically the standard for the Commerce Clause. Could someone who someday traveled in interstate commerce read this law? Yes, well, then that certainly affects interstate commerce. And Congress is free to pass any law that it likes. Again, you can think that's the greatest thing or not. It was certainly central to the Civil Rights Revolution in the United States, but on the other hand, it gives an extraordinarily expansive sweep to the Supremacy Clause. Now, when a case gets to the Supreme Court, then, it's really not dealing with a fundamental constitutional question, that question having been answered by the Supremacy Clause, but trying to interpret a vague statute or vague regulation, as shocking as it is to believe that Congress would write such a thing, given its proclivity for just being so perfectly clear. But the more difficult cases make their way to the Supreme Court, some ambiguous statute, we don't quite know what to make of the regulatory scheme or the preemption provision, and the Supreme Court is left construing text. So part of what the Supreme Court is doing, obviously, and part of what explains the different results in different preemption cases is different statutes being in play, where Congress has said with greater clarity that it really wants to broadly preempt state law than the Supreme Court by a broad majority, and there have been, including Medtronic. There was another case called Roe, which is another preemption case, this one involving transportation in the past few years. The Supreme Court is perfectly willing to find broad preemption or not do it by 9-0, 8-1 majorities if Congress speaks clearly enough. But the cases that concern the Supreme Court, the cases that concern you in your daily job of judging cases, are the harder ones. So, dealing with those harder ones, I want to talk about what I think the four principal things are that are going on with what the Supreme Court is doing in deciding these cases, and then talk about whether or not you should expect the tides to shift still further for or against preemption. The first thing I think the Supreme Court is doing in dealing with these ambiguous cases is allocating power between the states and federal governments. That's a kind of profound, big picture thing, and it's not entirely consistent with the notion that the Supreme Court is construing a statutory text or a regulation. But through a whole bunch of the Supreme Court's jurisprudence, the justices are deciding who gets power. So that we see you can have horizontal allocations of power where you have the Supreme Court saying we're going to decide cases about the Guantanamo detainees and we're going to decide whether or not they get in and out of court. We're allocating power to ourselves rather than to Congress or President or the President. It may shock you that the Supreme Court, when it decides who has power, the Supreme Court or someone else, generally decides in favor of the Supreme Court. And they have consistently done that. Now, there's a vertical allocation of power in our system of government. It's between the states and the federal government. And what the Supreme Court is doing in preemption cases is allocating power vertically. And they are, I think, trying to figure out what makes sense. So if you think about Medtronic, the medical device case, I think the Supreme Court looked at that case and said, look, we've got a bunch of expert people at the FDA who look at these heart stents, and like, we're all an average age of 94, and so we all have 7 of these stents things, and our lives are entrusted to these people. I sure hope they know what they're doing, but it kind of seems like an expert agency. On the other hand, when the FDA was dealing in the Wyeth case, it was really clear that this had become a political football with the FDA, and the Bush administration had said, we're really deregulatory, and so we're going to say it's the FDA's job. We're also going to fire all the people at the FDA who do this job, but still, the allocation of powers that this belongs to the FDA in deciding what the label should be. And so the Supreme Court thought, a sensible allocation of power is that this is not something where the Supreme Court is actually a very pragmatic group of people. They decided it would not make sense for that power to be allocated to the FDA, particularly if it wasn't taking its job there, at least as the Supreme Court perceived it, all that seriously. The second thing that's going on, and I think it's closely related, is that when the Supreme Court is allocating power vertically or horizontally, it has to decide if it has confidence in the party to whom it's allocating power. So that if you thought about the Bush administration with the Guantanamo cases, I think the Supreme Court lost confidence in the Bush administration's ability to genuinely and fairly adjudicate these cases and deal with them. And so, too, I think there are preemption cases where the Supreme Court thinks, gosh, I'm supposed to turn it over to this agency. Those people are a bunch of numbnuts. I'm just not going to do it. It's kind of that simple. The Supreme Court, there are agencies that the Supreme Court believes in and has confidence in and thinks they do a really good job, and it's much more likely, I think, and they have a consistent position rather than one that waffles back and forth between administrations. The Supreme Court, as a practical matter, is more willing to find preemption and put the issue in the hands of the expert regulators. And that's particularly true because the overarching thread in Supreme Court jurisprudence is to take authority and influence and power and opportunity away from the plaintiff's bar. If you were to think about just the swath of jurisprudence coming out of the Supreme Court, the one most common theme, if you think about cases about pleading standards, if you think about cases about jurisdiction, if you think about appellate cases, everything you can imagine, the Supreme Court has become, is a fairly conservative institution, has become very suspicious of regulation through litigation and the plaintiff's bar. Again, you can agree with it, you can disagree with it, but that is a wide trend in the Supreme Court's jurisprudence. And if the Supreme Court believes that expert regulators will do a good job, then it is much more likely to find preemption and to say we're going to take cases out of the courts and use a sort of door-closing methodology to its decisions. And I think that really helps to explain what happened in the Wyeth case, where the FDA was sort of blowing hot and cold on the question of whether or not it was preempting these kinds of claims. The third thing I would say is that we do have, of course, conservative justices on the Supreme Court and less conservative justices on the Supreme Court. We don't have a lot. We don't have a Bill Brennan or a Thurgood Marshall, a William O. Douglas in some contexts. We don't have a Harry Blackmun. But there are, of course, ideological differences in the Supreme Court, and the majorities in some of these cases, as Allison mentioned, are pretty thin. The Wyeth case is 5-1-3. Justice Thomas with a really interesting opinion saying he would never find implied preemption anymore. There's a case called Altria, which is a tobacco case decided 5-4. Justice Kennedy providing the fifth vote in both of those cases for the majority opinions. But ideologically, when you look at the cases, one of the big fights that's going on is a preference for regulation versus deregulation. The current perception is that you were talking about with preemption whether or not you're going to allow 2 layers of regulation, which Allison, who spends her a major part of her organization's life is devoted to fighting claims of federal preemption to allow state claims to go forward, describes as should the federal system be both the ceiling and the floor, or should there be another ceiling or floor through state regulation. And the more conservative members of the Supreme Court absolutely do have a general preference in closed cases to saying, look, we want less regulation. We think the general sort of attitude of Congress is to allow free markets to operate, and that's part of what's going on as well. And that's an easy tiebreaker that it helps to explain the ideology in the Supreme Court and why the majorities line up the way they do in the closed cases that are 5-4. Because fundamentally what's going on is that there has been a profound shift in what we ordinarily think of as the role of the federal government and the state governments. When you originally got into conflicts between the federal and state governments in the sort of modern Supreme Court era. What you were thinking about was the federal government as the guarantor of both consumer rights and federal and civil rights, right? It was federal law that was pushing the states to be more individually oriented. Now we have the reverse. Particularly after the last 8 years of the previous administration, where you had a deregulatory era, what you have is instead that the states are on the cutting edge, on the bleeding edge, on the pushing edge of forcing greater individual rights and greater protections, greater rights to bring claims into court. And so the attitude of the left and the right on the Supreme Court have conveniently flip-flopped. Right, the more leftwardly leaning justices on the Supreme Court, who in the 1950s and 1960s, 1970s, if they had been around, would have been very much in favor of stronger federal power, much more suspicious of state regulation and state rules. Now the reverse is true. When you find preemption rulings, it's quite likely that the leaders of that sort of approach to the Supreme Court's jurisprudence are actually going to be, and so more federal control, those are going to be on the right of the Supreme Court. But there has been this big attitudinal change as between the right and left that I think has something to do with the outcomes you're seeing. The last point that I want to address is how permanent the trend is that we might be seeing if you were to say, look, if I read the tea leaves, it seems like the Supreme Court is headed in the direction of being against preemption. If you were to say the biggest cases are really the Wyeth case, the Altria case involving tobacco, those are the most recent ones. Should I, as a judge who's trying to faithfully follow the Supreme Court's teaching, when I look at a preemption case, should my thumb on the scale basically be saying, no, we're going to allow state court suits to go forward? Well, for the reasons that Allison gave, I think it's more complicated than that. It depends on the nature of the claim. I think that implied preemption claims are going to be the very hardest to pursue because Justice Thomas has said he will never vote for them again, really. But here are the other factors that I think are in play. What's going on as between in these kinds of cases is very much in the Supreme Court a recognition of the important role not only of Congress, as I mentioned, because these are all about statutes, not only agencies, because agencies promulgate the regulations, but just the attitudinal posture of the administration as well. So with the Obama administration coming into office, having adopted the position that it's going to press claims of preemption less forcefully and less frequently, and only when there's a really compelling need than the Bush administration, that when the Obama administration advocates in the Supreme Court, that's going to cause the Supreme Court to be less inclined in close cases to find preemption. If the federal government in the Supreme Court is not advocating for preemption, it's going to be substantially less likely that in a closed case the Supreme Court will actually find preemption. There's also the overhang of what Congress is going to do here. When we had the Wyeth case, by early 2009, in the wake of the 2008 elections, the industry, I think, affirmatively wanted to lose the Wyeth case. As bizarre as that sounds, you got a big case in the Supreme Court on preemption. Why in the world would you want to lose? Well, because it was very clear that a Democratic Congress was going to overturn any decision that was in favor of the industry. And so one thing that the Supreme Court is, as a practical matter, is recognizing is that it is going, if a conservative Supreme Court is finding preemption and throwing out individual rights claims under state law, it is going to be butting heads not only with the position of the Obama administration, but with a Congress that, if it accomplishes anything, which is an open question, is going to be willing to pass laws that overturn findings of preemption, as they are considering overturning other decisions of the Supreme Court. Take the Lilly-Ledbetter Fair Pay Act and other contexts. The Democratic Congress is willing to go to bat to some extent for the plaintiff's bar, for the right for these claims to go forward. So I think if there is no profound anti-preemption majority in the Supreme Court, these cases remain closed. The Supreme Court, in an appropriate case with the right preemption preemption provision in the statute, will find preemption. But the attitude and the trajectory of the cases, I think, is against preemption.